Hi, welcome to our presentation where we're going to critically discuss legal subjectivity with reference to vulnerability theory using the case study of supported decision making. When we talk about legal subjectivity, we're referring to how the law should be applied differently from case to case depending on the context and individual circumstances of the person in question. Subjectivity shows us how judgments are made based on the person's own experiences, and often the law refuses to take this into account. It typically goes off what the reasonable man would do, which involves applying the same criteria for every person when deciding on the outcome of their case. The liberal legal subject is used, which, as defined by Rosemary Hunter, is male, autonomous, self-sufficient, self-contained, self-possessed, and equal before the law. By using the same criterion for everyone, the results of cases are often unfair, as circumstances are always different, and therefore basing and comparing someone to the liberal legal subject is classed as unjust, as not everyone is self-sufficient and autonomous, which we'll see later on in more detail when we compare this to those using supported decision-making. And so, on the other hand, with legal subjectivity, we're essentially considering all the factors which may have contributed to a person's particular decision, and we're basing the decision on the case off this as well.
Martha Feynman's vulnerability theory claims that the liberal legal subject is a fiction and rejects the normal definition of vulnerable, which she defines as associated with victimhood. She instead argues that everyone is vulnerable in the sense that they are dependent on others and socially embedded within relationships and institutions. There are two strands of vulnerability theory, embodied and embedded. Embodied is being physically vulnerable as a human, and embedded is where we are positioned differently in a web of economic and institutional relationships. The level of vulnerability is dependent on resources. These resources can be seen by Feynman as physical, human, social, environmental, and existential. Resources are not always equally distributed. As human beings, we can depend on resources to make a person more resilient, and resilience is produced over time and through social interactions and experiences. Feynman argues that all these dependencies are usually pushed into the private sphere and should force the state to be more responsive. Beverly Clough applies Feynman's theory to supported decision-making, putting into context the strict binary the MCA holds at the moment. The capacity-non-capacity binary is directly linked to legal capacity, and this means that if they are deemed to lack it, the decision will be made for them by the court under the MCA. Vulnerability theory would argue that supported decision-making was allowing people with disabilities to make the best decision possible, and shared vulnerability would force the state to distribute resources in such a way as to enable meaningful choice. Clough posits that the MCA is based on the autonomous liberal legal subject, and since this is a fiction, according to Feynman, this is no longer the best way to make decisions for those with impairments. Nina Acorn has argued that there are potentially some flaws with the theory itself, that it does not indicate how to allocate resources among individuals, and that Feynman criticised approaches of law reform that focus on the needs of specific groups of people, yet focuses on the specific laws of the elderly, which moves towards an identity-based approach, which she criticises.
The CRPD Article 12 sets out rights for people with disability, including supported decision-making. CRPD is linked with Feynman and legal subjectivity. Article 12 states that disabled people can exercise legal capacity despite lacking mental capacity. This is legally subjective as it is looking beyond what's objective and reasonable. It supports vulnerability theory in the responsive state because in supported decision-making, the state is involved with the autonomy of the less resilient. It supports Feynman and social embeddedness. We see that vulnerability is embedded in social relations and institutions and that we are dependent on each other for support. CRPD is positive because it empowers disability through supported decision-making so that disabled people can have legal capacity. This is advantageous if the person struggles to communicate as they can still make decisions. Supported decision-making ensures that capacity impairments are not barriers to autonomy. CRPD allows disabled people to have equal status before the law. This is important because it prevents discrimination and ensures the exercise of rights. The strength of supported decision-making is it has application to dementia patients. Patients' family members participate in supported decision-making when choosing treatments. Mariani et al. Found that it was successful, emphasising the importance of family caregivers. However, there are issues with supported decision-making, as the needs of the person may be misunderstood or the person may end up influenced by the people supporting them, meaning the decision isn't genuine. There may be too much interference with the autonomy of the disabled, which may be responsible for these problems. There are risks with supported decision-making. Supported decision-making reflects the wishes of the person, but they may have negative outcomes, for example, if they wish to reject treatment. Arguably, the person's wishes must be treated with caution because they lack capacity. Substituted decision-making may be more appropriate to ensure the well-being of the person by taking account of the best interests. Supported decision-making is criticised as utopian in relation to severe impairments like a coma. In these circumstances, it's impossible to avoid substituted decision-making because a person cannot function.
The Mental Capacity Act is the current legal mechanism for decision-making under UK law. Section 3 of the Act sets out an objective test for determining whether someone has the mental and legal capacity to make a decision. The fourth section of the Act is an attempt at incorporating the supported decision-making element of the CRPD by stating that decisions should be made in the individual's best interest. There are many problems with the Mental Capacity Act. Firstly, the Act equates legal capacity with mental capacity, diminishing the notion of universal legal capacity and therefore rejecting legal subjectivity. Stabbett states that mental capacity is in fact contingent on social and political contexts, meaning that attempts to cognitively and objectively assess capacity are unnecessary and discriminate against those who cannot make decisions alone. The idea of social embeddedness put forward by Martha Fineman is not accounted for in the Act, as your ability to understand information is seen as an individual one rather than one done with the collective assistance of others. Under Section 4, it is not clear how much weight should be given to individual views as case law is conflicting. For example, in RES and Another, Judge Marshall introduced qualifications emphasising the weight of individual wishes. In REP, Lewinson J stated that Marshall had in fact overstated the weight given to is ambiguous, and it appears to be about what's seen as best for the individual, as opposed to addressing their actual wishes or assisting them through supported decision-making. However, the Mental Capacity Act is an adequate test for those who have very little verbal reasoning and communication skills. The best interest test can be determined by family members or carers who actually understand the individual in question. Overall, the Act does not offer support to individuals making decisions. It gives them no legal agency if they don't pass the test under Section 3. The broad spectrum of mental impairments requires UK law to be more specific to cater for these differences. The current law fails to cater for those outside of the legal norm, meaning that vulnerable members of our society do not have adequate access to their rights.
The CRPD signifies a fundamental shift in the law's approach to mental and physical disabilities and clearly supports Fineman's vulnerability theory. However, some have still suggested the need for reform surrounding the law set out in the CRPD. This is argued by Schmulka and Dawson, who say the conventional law was unfairly discriminatory against those with mental illnesses. This shows that despite the convention encouraging social embeddedness by allowing people within supported relationships to become more integrated, it is not inclusive of those with mental disabilities. So they proposed a generic law, which they termed a fusion law, that would not take the blanket approach that the supported decision-making in the CRPD does. This could ensure a fairer legal framework, as sometimes the CRPD has been criticised because of its broad take on supported decision-making, especially in relation to the context of severe impairment, where this may not always seem appropriate. Moreover, Shelton and Gardner advocate for an alternative model, which is to combine the strengths of the competence model and the model of supported decision-making. Overall, the CRPD is a good social approach to questioning and removing the liberal legal subject, however, can sometimes be perceived as too broad. Therefore, it's important that we strike a balance in ensuring the empowerment of individuals within supported relationships and move towards legal subjectivity.